Canadian Conservatives, both on the provincial and federal levels of government, need to get way more serious about the issue of court appointments in this country. I know as soon as you bring up court appointments and actually wanting more conservative and charter respecting people on the bench, the legacy media and the left wing political parties are immediately going to attack you as trying to Americanize Canadian politics, as if because Americans care about an issue, if you care about it as a Canadian, somehow you're doing something wrong. Conservatives need to weather that stupid storm because the courts are going to get in the way of a lot of legislative reforms that we want to pass. The best example of how far left the court has become is a story out of British Columbia where the BC NDP actually tried to do something very good, which was trying to re-ban, recriminalize, as the left would say, illicit drug use in public areas, also trying to make sure that people can't use drugs like right next to storefronts and all this sort of thing. Just basic stuff anyone would expect should be illegal in a province. So the British Columbia NDP put forward legislation to ban illicit drug use, and the BC Supreme Court actually blocks that from happening. They put a pause on the legislation until modifications can be made under the guise that somehow they're going to cause harm by not letting people basically poison themselves on the streets based on the the cries of activist groups saying that criminalization will harm people and that if anyone is hurt because they aren't given safe supply drugs and they're not allowed to use drugs in a public park and they have to do it in their own homes, that somehow is going to make it more difficult from third parties helping people who are overdosing on the streets. They're never investigating. The court never even considers the fact that British Columbia is becoming the overdose capital of Canada because of loose drug laws that are encouraging people to use drugs. And you could say, well, they're not encouraging people to, they're just trying to keep people safe. Well, if you put more of a safety net in place for bad activity, you're going to find a lot of people are going to gravitate towards that bad activity. Just because you, in your upper middle class bubble, thinks it's a bad idea to smoke meth on the streets doesn't mean that you're not going to have a specific demographic of people that if you make it easier to do meth on the streets are then going to start doing it. You can't be shocked that people are going to follow incentives, as silly as the incentives are. But I want to start talking about this court case and the conclusion of this decision because it is wacky and it demonstrates that we either need to find a way of getting these people off the bench or once they retire, we need to be forcing through conservative court appointments to make sure that the people making decisions on in court cases and on legislation challenges are not far left sociologists because these people do not sound like real lawyers or judges. I say lawyers because you have to be a lawyer before you become a judge. These people do not sound like they actually understand the charter. They just see the charter as a vehicle to push far left insanity. The fact that they're running up against the BC NDP is a big sign that the people getting on these courts are so political, they probably wouldn't even get through a BC NDP nomination without being considered so radical they get disqualified. But so Supreme Court Chief Justice Christopher Hinkson issued this decision. I'll bring it up on screen because I want to read the conclusion. It was like I just want to read who it was that intervened in this case. Sorry if I start sounding a bit clunky here. It was the Harm Reduction Nurses Association was the one challenging this decision. I don't know why activist groups can challenge decisions from the legislature based off of not even being a relevant plaintiff, but I guess the BC courts will hear you if it gives them an opportunity to strike down legislation that they don't like. And so this entire case is based on the idea that this legislation by the BC NDP will harm the ability for nurses and other third parties from intervening and helping people who are overdosing by, because they're using dirtier drugs or because they can't use it in a public park, they're going to use drugs somewhere where it's still technically legal and it's farther away from people who can help them or some other nonsense. It's like the BC government argues, it's all based on anecdotal examples. There's nothing actually substantial to the argument that the Nurses Association, the Harm Reduction Nurses Association is making. But the court just decides that they don't care because they agree with the nurses. And it's exactly how this thing reads. So on line 89, the conclusions on irreparable harm, because they argue that somehow this legislation will cause irreparable harm. It reads, given the evidence before me, I find that there is a high degree of probability that at least some of the harm set out by the plaintiff will in fact occur. Some, that's a little bit odd. So they only had to prove that some harm could be done by this legislation. Whatever, sorry, I'll keep reading. Centrally, but not exclusively, the Act will promote more lone drug use, which carries incumbent risks of PWUD. That's the idea that like it risks to PWD, third parties trying to help people overdosing, or it's putting them at greater risk, or whatever. So it carries incumbent risks to PWUD and also the plaintiff's members. Line 90. The province argues that the plaintiff's evidence is composed almost entirely of affidavits prepared by administrators of public interest groups that are replete with anecdotal evidence, unsubstantiated conclusionary statements, layers of unattributed hearsay, inadmissible expert opinions, and public recommendations. The evidence, it argues, is generic and therefore without necessary convincing level of particularity, and is factually untethered from the actual restrictions contained in the Act. I find it necessary, this is line 91, I find it unnecessary, however, for me to place reliance on what the province describes as anecdotal evidence, unsubstantiated conclusionary statements, and layers of unattributed hearsay and policy recommendations, as I find the evidence adduced by the plaintiff from the death review report on its own could establish the risk of irreparable harm to at least some of the plaintiff's members and to PWUD. This is blatantly insane. The judge, Justice Hinkson, is arguing that because you can maybe prove that by restricting drug use from these sort of safe injection sites, from this like safe supply program and in public parks, because by getting rid of some of those services or by not allowing people to use drugs publicly, that there might be some level of higher difficulty in treating someone overdosing, that means this legislation can't be passed. That is insane. This is basically saying, and the idea that because some of what the plaintiffs is saying could cause harm, we can't have any legislation. We should just ban legislation entirely and live in an anarchy, because that's what this justice is effectively saying. If he can even imagine a hypothetical situation where someone overdosing is harder to help because we don't let them use meth in a public park, that means this legislation is somehow bad. The guy has to ask himself, well, why is it that Alberta, Manitoba, Ontario has lower drug death rates than BC, who has all these safety measures? The idea that somehow because per capita drug overdose deaths, so the amount of times you have to overdose before you die might go down because there's like less safety nets around, is somehow means that this is going to cause irreparable harm. Maybe in the immediate short term, there might be a few more deaths because of overdoses, but his argument would say that we can never enforce drug laws, because if we do, the few people who are using drugs might become more at risk of death. That is insane, unethical, and it's actually going to cause more people to die in the long run. This guy, Hinkson, is not arguing anything that's actually legal. He's basically bending to political arguments. And I believe it's because he himself is extremely political. I just want to create a couple more things here. It's just so baffling when you read this. So this line 92. The plaintiffs suggest that in a case like this, where the fundamental rights and lives and safety of marginalized people have been put at risk, the balance of convenience should fall overwhelmingly in its favor. That is insane. That is an insane line I have just read. That because something might affect people that we have defined as marginalized, the convenience of like basically the evidence, the way that we should read the evidence should be like heavily in favor of them. If you can find someone who is a minority in some way, who is affected by something, basically the state and courts should bend over backwards to help them. And this is ridiculous. This drug legislation trying to ban the public use of fentanyl in BC is going to help people who are using drugs the most, because it is going to stop them from like diving deeper into their addictions by having the state just kind of like turn a blind eye to it. It gives the state more resources to intervene with these people so that they're using drugs publicly. There is a reason now that the police can arrest them and potentially force them into rehab. That is good for them. The BC courts think someone basically deteriorating on the streets using heavily toxic opioids, that's actually good for them because somehow they're black. So that ergo means, that's just an example. They're black, so ergo criminalizing drugs is bad. That is actively left-wing insanity. I just want to keep reading a little bit more of this. I'm sorry, this is a little bit painful. Uh, and then so he goes on to say, it contends that in light of the province's actions in changing the status quo, the status quo has only been around for a couple of years, but now it's status quo. I know status quo is just whatever the current situation is, but like the current situation is very out of the norm for both British Columbia's history as well as Canada as a whole. There's very few places you can find as nutty as BC is on the issue of drugs. And the BC and NDP is actually trying to reverse it because it's just so obvious that what they're doing is insane. So anyways, I'll go back to reading that. It contends that in light of the province's actions in changing the status quo, it has acted swiftly to seek relief that is deemed unnecessary. The province responds that it must be assumed that the act poses a public benefit, and the court should assume the plaintiff is acting in its own interests, and that an interim injunction would deprive the public from benefits of the law. Yes, that is 100% true. That if the act clearly benefits the public, it clearly benefits the public for less people to be using drugs in a children's park. I'm not sure why I need to explain that to a left-wing judge who probably stole his law degree based on how bad this is. But like because there is like he's arguing that the province can't argue that there's potential benefit, but you're letting the plaintiff argue that there's hypothetical potential harm, and that they don't even get to, and there's not even harm to the and the province can't even argue back there's harm to leaving the status quo in place. This court decision is basically saying I'm going to let the activists win, and whatever you say in response to me, I'm going to put my fingers in my ear. That is what this judge is saying. This guy is an embarrassment to the legal system. But to go on a little bit more because it's just kind of funny to me at this point. It says, in addition to the law on public benefit set out above, in whatever some court decision, consider injunction against Crown explains. This is from another legal decision. Such relief should not be granted without a consideration of the public interest, including the public interest in the legitimacy of public institutions. The public interest includes, in my view, a high level of respect for the decision of the legislative and executive branches. Well, this judge is just walking all over the decision of the legislative and executive branches. He's basically saying, well, I don't care if there's any benefit, but he's pretending he's being balanced. So he says, in my view, a high level of respect for the decision of the legislative and executive branches of government, the jurisdiction of the courts to enjoin, impugn government actions, which may or may not in the end be found to be unconstitutional, must recognize the court's own limited institutional competence and public interest in having publicly elected bodies and officials enact legislation and determining public policy. So he's pretending that like somehow he is still respecting the ability for the legislature to pass its own laws. And that the insanity of this, it's basically insane court decisions referencing other insane court decisions saying that, well, whether or not the legislation is actually going to benefit British Columbians is neither here nor there because I can invent a scenario in which the current legislation could do something bad to somebody. And guess what? Every piece of legislation is going to somehow harm somebody. There's no question, because we live in a big crazy world, and even the most obviously good piece of legislation, you'll find somebody it somehow hurts in the most subjective, like fringe way possible. And this court is basically saying that because I can invent fantasies in my head, or because we can find one person who might OD because they weren't allowed to keep doing meth in the middle of a park, ergo this legislation is unconstitutional. Insane. I hope that the BC government appeals this to the Supreme Court of Canada, and the Supreme Court has a few brain cells in it that they actually defeat this decision. It's insane. But this is why, sorry for how much of this has become a rant, but this is why Canadian Conservatives, federally and provincially, need to ram through better judges. I don't care if they say, oh, these people seem partisan, they seem conservative. The Liberals don't care about that, so the Conservatives shouldn't care. Because at the end of the day, we should have people on the court, no matter what their party affiliation is, who understand how to read the charter, understand the place of the court, and aren't just a bunch of activists using the courts because they couldn't get elected themselves. If you're just too incompetent to get elected in a party system, to get in the legislature, and you still want to make decisions, go write a book. Go write a book about you being a progressive hero. Don't get on the courts and start shoving that down people's throats. It's disgusting. Anyways, this should be it for me today. I have my usual Give, Send, Go link in the description of this video. If you want to contribute, I'm being sued by a billionaire. It's an obviously stupid defamation case. Speaking of stupid court decisions, I wish in Alberta we had anti-slap laws that would actually allow dumb defamation cases to be thrown out early, but we don't have that. That is more of a legislative problem, but whatever. It's a completely ridiculous case. If you want to contribute, you can give $5, $10, $15 to my legal defense. It helps pay down my $25,000 legal costs. Other than that, I'm also running for the Calgary Signal Hill Conservative Party nomination. If you live in that riding, make sure you and your friends have Conservative Party memberships. Vote for me in the nomination. Number 1 on your ballot. It's a ranked ballot system. That's Calgary Signal Hill. Look it up. See if you live in the riding. And you can check out the website. I have it also linked in the description. I know I make a lot more videos where I seem to just rant on, but this decision from the court did require me to do more reading. And it's just so horrifying that there's nothing to do but just say that it's stupid and just talk about how incompetent this Justice Hinkson is. This guy's not a judge. This guy's just like a sociologist who somehow snuck onto the court. Anyways, I can't believe I'm actually having to back up the BC NDP and Premier Eby, but this is what we've brought ourselves to, is that even the NDP is not far left enough for the BC Supreme Court. Have a great day, everyone.